Hello. This is a recording of the webinar that we ran this morning on restructuring redundancies, in case you missed it. This is the fourth of a series of webinars directly related to COVID-19. Initially, we talked about navigating the employment relationship. We touched on employee and employer wellness, and we had a session on leadership and motivating your employees back to work. The leadership one is on our website, and because that's more general in nature as opposed to just for COVID. But if you're interested in any of the other sessions, then please let me know and I can get a recording to you. Today's session is on restructuring redundancies and what you need to know. Unfortunately, it's not a very exciting topic to deliver. So I have tried my best to keep it simple. So think of this as a bit of a crash course. If your business is ever in the position where you need to undergo changes or employment conditions or a restructure, then seek advice from an HR expert or an employment law expert. I know that it can seem like a lot of money up front, but it will be an investment in mitigating your risk of personal grievances. But it'll also help give consideration to the mental impact of the workforce and the managers that are involved, especially when having to deliver difficult conversations. People Plus is a Gisborne local human resource and employment relations and immigration consultancy service. We offer advice and support during tough times, but also support in all stages of the employment life cycle. So that includes attraction, recruitment, retention, employee development, pay evaluations, and just general business support. I'm Jenny Curry, the Director of People Plus, and I suppose in relation to restructure and redundancies, unfortunately, I have far too much experience in the planning and executing of change proposals, both large and small scale. I spent the early part of my career working in HR for a civil construction and mining business in Australia. I was in Western Australia when the downturn in the iron ore came off, and then I was living in Queensland when the coal seam gas came off. So in the space of a couple of years, probably fronting for, I would say, at least 300 redundancies. And that was really difficult, especially because I knew these people, I had a relationship with them, I worked with them. So I thought today I would try and share some of my learnings from having been part of those, the planning and the conversations for those, in terms of negotiating change. Unfortunately, businesses do sometimes just have to make those hard decisions before it's too late. And so it can come as a shock for those employers that are involved. So unfortunately, it looks like we are going to head into a fairly significant economic downturn. Businesses are going to be impacted in various ways. Unfortunately, for some businesses, the impact of COVID-19 has hit really hard and fast and resulted in redundancies for employees already. If you're attending this session because you need to go through a change process, then I encourage you to reach out to me after the session. We can have a confidential chat to see how I can help. There is government funding available for businesses due to the impact of COVID. So if you qualify, that's likely to cover the cost of our services. I am hearing that there are a lot of businesses locally that are finding opportunities and that business is still strong. So if that's you, then I encourage you to stay here for this session because we're going to talk a lot about the process for change and the changing employment conditions, which may be required if you are seeking out new opportunities or diversifying. So we'll talk about restructuring, we'll talk about your obligations as the employer, and processes that you need to follow. And then I'll touch back on the wage subsidy, and if you got the subsidy, what that means in terms of the declaration that you sign. So restructure is a workplace change that affects employment conditions. This could be anything from reporting line changes, changes to hours or days of work, the scope of the role, or reduction in pay or duties. Or it may include changes where roles are being disestablished, which may result in redundancies. Depending on the scale of change will ultimately determine the level of communication and process required. What's important to understand is that you cannot just change an employee's employment conditions without an agreement from them. As an employer, you've got the difficult job of ensuring you follow all of the relevant New Zealand legislation when it comes to regarding employment. This isn't the full list that you need to be considerate of. This is just a few pieces of legislation that I think are really important when it comes to change or restructure. So the Employment Relations Act requires you ultimately to act in good faith in all dealings with your employees. The basic principle, I suppose, when it comes to changes in employment conditions is that you consult with employees and you follow a fair and reasonable process, which we're going to talk about. The Health and Safety at Work Act, you are obligated to consider the health and safety and protect the health and safety of your workforce. But this also includes mental well-being. So ensuring you've got a process which is communicated clearly and follows a well thought out plan will minimize the mental stress of your employees. If you manage a change process poorly, this may impact the mental well-being of your employees. And there's nothing worse than trying to make change and having employees off on stress leave. The Holidays Act and Wages Protection Act are important. You need to know your obligations in regard to paying out holidays and wages. I often hear of employers trying to withhold pay from employees on termination, and that might be for things like tool accounts or training that they have provided. You really need to know your stuff if you're going to try and do that. So if you don't, just give us a ring and we can kind of evaluate the situation case by case. In the Human Rights Act, this is important to include when considering a restructure. You need to take care that there is no discrimination in employment on the basis of age, sex, religion, sexual preference. So I suppose for an example, when it comes to restructures, say you had two employees who are both in the same position, and you needed to disestablish one of those roles, you would need to have a clear selection criteria, which we'll talk about soon. And you couldn't say something like, oh, well, he's older, so he's not as fit, as that would create grounds for discrimination. And that exposes you to complaints in the Human Rights Commission. And you really don't want them knocking at your door because typically penalties from the Human Rights Commission are significantly higher than those that you attract through the Employment Authority. I want to make a quick side note in regards to discrimination in the recruitment process. So I've heard about this happening a lot where applicants are asked their age at the interview. Just don't ask that question, okay? Because it's likely to open your exposure for discrimination. If you don't hire that person, then they could potentially have a claim, or even if you did. If this is news to you, then I suggest you go Google discrimination in the workplace and do a little bit of reading from the government employment website. So why is it important? Well, if you don't meet your obligations as an employer, then your employee or employees may have grounds to raise a personal grievance. for failure to act in good faith, or for an unjustifiable disadvantage or dismissal. If you fail to meet your obligations, then you may end up in mediation or in front of the Employment Relations Authority or the Employment Court. There are some stats that indicate that the cost to employers is on average about $25,000 by the time you factor legal costs, lost time and settlement costs. This is an estimate because it's hard to measure the true cost, especially when mediations are settled confidentially. It's not just the financial impact you need to worry about. It's also the mental, it can be mentally draining, and it can take a toll on your business reputation and employee engagement. So it's important to spend a bit of time up front and get the process correct. It's really simple. There's just 2 golden rules that you need to remember for the employment change process. You must have a genuine business reason to make change, which you would need to be able to defend in court. So if your reason was decreased revenue, you would need to be able to be ready to justify and show evidence for that. You must also have a good faith process, which means you need to provide the genuine business reason to the employees and propose the change, seeking their feedback for consideration before you make the decision. And we're going to talk about that in the next slide. I wanted to talk about the importance of employment contracts. So it is a requirement for you to have employment contracts in writing, but it's also really important to have employment agreements that suit your business operations. When it comes to change, you're going to refer back to the employment conditions that you agreed, and having no contract will make your process a lot more difficult and will give the employee a lot more rights, as there's no minimum agreement in place. If you have employees that don't have agreements in place, then I would suggest that you get on to this. We can help to make sure they are reflective of the type of work you deliver, such as casual or flexible, or for example, say you have business operations that run Monday to Sunday and you require flexibility in that time. You can get the templates off the government website, Google Employment Agreement Builder. It's on the .gov website, I believe, and that's a really good start. But if you are looking for, if your business operations are slightly varied, then yes, just seek some support on that, because it can be really helpful. So when you need to make a change that's going to impact on employment conditions, you need to have a good faith process. It's important that you plan your process in advance, so give regard to the time it's going to take to run that fair and reasonable process. So if you have a date where change needs to occur, then work back from that date and allow some time for delays. Once you've got the plan and the written communication ready, then you need to communicate that. So firstly, you'll need to consult with your employees. This means speaking individually with any employee whose role may be impacted more significantly. So that might be if the role's changing significantly, or that role is being disestablished. And then if it's a change that affects the wider employment group, then you would then communicate the change to the rest of the group. That may not be necessary if it's just looking at one role, or change to a small group that might be wrapped up within just that group. You then should follow up that communication in writing. So the written document will provide the genuine business reason and the current state of play and the proposed new structure. So it's very important at this stage that you have not made any decisions and you're seeking feedback before you do. The written proposal could be as simple as a 1 or 2 page letter or it may be a more comprehensive document depending on the size or the scope of the change. So last year I supported a business going through quite a wide scale change, and their written document was about 25 pages. But that was because there was change across different departments and current org charts and the proposed new org charts. So quite a comprehensive change process. But we also do changes which are email in writing, or a one or two page letter in writing. You need to provide, I suppose, a reasonable time for people to provide feedback. And what is considered reasonable is really going to depend on the scope or the impact of the change. So if, for example, you're just looking to reduce hours or days for an employee, then potentially you may only need to give sort of 3 days to a week. But if you're looking to just establish roles or make more significant change, then you should really be giving at least a week and potentially 2 weeks. This is going to allow them adequate time to seek legal advice or advice and get back to you if they wish to. And you always need to be open to really extending that time frame if it's requested. The feedback stage can be really interesting. You will get a good indication from your employees if they're supportive of the change. But you'll get some real insight into what they're thinking, and so often this can make you change your decision, and it's really powerful when you go through these processes when the employees can see that they have been listened to. Once you've considered all of the feedback, you'll then need to make a decision and communicate that to your employees. So again, communicate first with those that are adversely affected before you communicate to the wider group. If there's changes to roles, then you need to get this agreed in writing. So that might be a variation to the employment conditions or a new employment contract. If roles are being disestablished and you have vacant roles available, you must consider redeploying those employees into those roles first before you consider redundancy. Your obligation is to redeploy. So if you're not, then you need to be really confident that those employees do not have the skills or experience to redeploy into that role. And don't just assume too, because potentially they've got some qualification that they've never told you about, and they would be able to be considered, and you haven't followed a full process. So I'll talk a little bit about the selection process. So if you have multiple positions that are being disestablished with some remaining or some new vacant positions, then you must have a fair and reasonable selection criteria, which you do need to consult your employees on. So you may choose to consult with them right at the start of the process, or it might be now once you've made the decision. And that really just depends on the makeup of the change that you're doing. So suppose an example, say if you imagine you own a motel and you had 4 cleaners for that motel. Due to Covid-19, you no longer have the customer numbers. Typically you relied on 50% of international guests, and subsequently, so your room bookings have halved. So you're proposing to disestablish the 2 of the cleaning positions, and you're now seeking feedback. But if you were going to go ahead with that decision, you're proposing that you would use the following selection criteria. And that might be qualifications, experience, attendance, and performance. And you've sought feedback on that from those staff members. When finalising your decision, you would evaluate the 4 cleaners based on the selection criteria, and then you would advise the employees of the outcome, and ultimately making 2 of those employees redundant. You need to be careful to protect the privacy of your employees' information. However, at this stage, usually the employees start talking And if they agree, they might want you to share that selection criteria with them. But if they don't agree, then yeah, I would refrain from doing it. I've got performance on there, but just take care if you're using performance in your criteria, because you can only really rely on performance when the employee has been made aware previously that there was an issue. So you would really need to have some kind of record of communication where you had advised them of their performance or a performance improvement plan. So this is, I suppose, the minimum process that you could run, and this process would be for, I would suggest not when you're just establishing roles, unless the business was closing completely, or unless there was, it was quite significant that you had to run a very quick process. This is probably the process that you would run for a change to employment conditions of a smaller scale. And this is probably the process we've been running over the last couple of weeks in regard to reducing people's pay to either the 80% or to 585. So you really need a business case. So that might be a written letter, or that may even be an email, depending on the scope of the change. If it's an email, you need to kind of make sure that your staff are receiving emails or that's relevant to the workforce. Consultation could be just a couple of days, gather the feedback and then make a decision. So some things to consider, especially before you're just establishing roles, really need to make sure you've explored all of your options. You could look at some temporary measures, or you could ask your employees to take unpaid leave or paid leave. Or reducing hours, or even reducing pay. It's good to explore those options before you move to sort of the last resort. Always remember to protect privacy and confidentiality of your employees in any aspect of employment. Don't have any predetermined outcomes. Be genuine in seeking feedback from your employees before you make a decision, and that will avoid you having the predetermined outcome, and it will avoid you communicating it incorrectly as well. Consider the support options for your employees. So large organisations usually have a confidential employee assistance program. That's not, I mean, you don't have to have that, but if you are going through change, then it's good to try and get some support options available. And that may even be just providing the contact numbers for free advice lines at the bottom of your communication. You can also seek resume writing or interview training and that job seeking support as well. Make sure that you consider the post-change. Change is difficult for everybody, so consider how you're going to rebuild the workplace culture in a genuine way out the other side of this. So I thought I'd quickly touch on the wage subsidy as discussed. So there was a change to the declaration. So if you applied for the wage subsidy and you've received that for employees, you would have signed a declaration. And you may not remember because you were frantically trying to apply for that just before lockdown. But it does depend on when you applied if you are going to make redundancies. So pre the 27th of March, if you applied then, that original declaration still remains. And the employer can make the employee redundant. However, they have declared that on their best endeavours, they will continue to employ their staff on 80% of their income. The declaration changed on the 27th of March. And employers that applied for the subsidy after that time cannot make their employees redundant for the duration of the subsidy, so for the 12 weeks. Employers were able to rehire any employees that they had let go of before before, during that period of uncertainty, so that they could then apply for the wage subsidy and pass that on. The employers also declared that under their best endeavours, they would continue to employ each employee for 80% of their wage, or at least pass on the full amount of the subsidy unless they earn less than their usual wage. So, I suppose what can you do now? So we've been supporting employers over the last few weeks with changes directly related to COVID. So for most of these businesses, there's still so much uncertainty about what the coming months are going to bring. But what we do know right now is that things were not as they were before. So it's really important to take the time to reflect on what's going on and what changes are occurring within your business. There's new opportunities presenting themselves each day. So make sure you're alert and looking for those and responding quickly. I'd encourage you to speak with your staff and get their ideas and input to the decision making. Breakthrough innovations and advancements to productivity usually come from the people actually doing the job, and that's because they're motivated to make their lives easier, so often not from the top down. At the moment, your business potentially has a very strong, genuine business reason to propose change to employment conditions. So now would be the time to consider this. We've been working with employers to propose short-term variations to employment, such as reduced hours and pay for the next 2 months, for example, and job changes, which we'll review when there's a bit more certainty around the state of play for the months to come. I strongly encourage you, I suppose, to reach out to one of the local growth advisors at Trust Te Rāwhiti, if you haven't already, because they may be able to help get funding for your business for human resources or wellbeing, which we can help with, or financial planning and business continuity. I think that's going to be really important, and it's really good that that funding is there to support. Cool. And that's all we had for today's session. This is a recorded session to keep the confidentiality of the questions asked in the live session. But thank you to Trust Te Rāwhiti for making these webinars happen. If you need support or guidance, then please reach out to them, or please reach out to us at any time. Thank you.